This podcast is not intended as legal advice. If you're in need of legal services, please contact 602-375-6752 to set up a consultation. You're listening to the official podcast of the Law Office of Libby Banks, Estate Planning, Wills, and Trusts. Your estate planning attorneys in the Phoenix Valley.
Hello, welcome to the podcast of the Law Office of Libby Banks. I'm Libby Banks.
And I'm Allison Gloss, the Associate Attorney.
We're glad to have you here today. Today we're going to talk a little bit about trustees and their duties. So one of the things that we often hear is, my trustee knows what to do. But often we sometimes hear from a successor trustee, as I did the other day, who says, my friend said that as trustee, I can just do whatever I want. But I'm thinking that's probably not correct. And of course, it's not. So let's talk today a little bit about what trustees can and can't do, and in particular, the importance of the responsibility of being trustee.
Yeah, that's funny that you say that, Libby. In consultations, it often comes up with clients that will say, well, I don't want to play favorites by picking one of my kids as a trustee if they're going to pick a child. And I try and tell them that this is not about picking favorites, because being a trustee is definitely not a party. So.
Yes. Absolutely. Mm-hmm. It's a huge responsibility. Some would say a burden, and just important to really pick the person who's best, whether that's the oldest kid or the youngest kid or the middle kid, or it's somebody not one of your kids, right? Which is often what our clients do as well.
Yes.
Absolutely. Mm-hmm. Well, one of the main things that trustees need to understand is that they have a fiduciary duty. So they are a fiduciary. They are held accountable for their actions. And so it's really important to know what their duties are in addition to that general fiduciary duty. So one is to follow the trust document. So the trust directs how things are to be distributed and to whom. And that's an important thing to note. Not just to whom, but sometimes how it's to be distributed needs to be understood by the trustee. So often in our office, we have the trustee or the trust distributed in subtrusts for the individuals who are inheriting. So it's something to know that it may not be just writing a check when everything's wrapped up. There are other directions in the trust as well. The trust administration, there's trustee powers, and sometimes there's limits on the powers. So it's important for the trustee to really look over that trust document.
Right. And for a lot of trustees, they're lay people. And so it's important sometimes to consult an attorney. So somebody that's trained to know what these words mean and all the legalese. So.
Absolutely. And, trusts can be very long. So there may be some things in there that they won't notice if they're not well-versed in what the law is and what the trust says. Some trusts are written before the change in the law, but the new law applies. So they would have to be able to get what is the current law, not just what the trust is.
Right.
So we do recommend usually, whether it's us or someone else, that a trustee have a lawyer tell them, what does the trust say? What are my obligations under the trust? And what are my permissions as well? Because sometimes there's also some permissions and flexibility in the trust.
Right.
One of the other obligations is a duty of loyalty and a duty to those beneficiaries and a duty of impartiality. Those kind of go together because the loyalty is to follow the directions of the person who left this trust, that created this trust. But there's also a duty of loyalty to those beneficiaries, making sure that they're performing to benefit the people who ultimately are getting the benefit of the trust, and to be impartial, so we don't favor one beneficiary necessarily over another.
Or favor yourself.
That is a great point.
Because trustees can also be beneficiaries, which we see quite a bit.
Yeah, absolutely. And if they're not, they're certainly entitled to be paid. At least our trusts always say that. Sometimes there's special provisions about payment within a trust, but they need to make sure that they're doing that properly and they're not favoring themselves by giving a huge amount just for the work that they do if it's not appropriate. There's also the duty to do reporting and accounting. And so often we will get a call from a beneficiary. There's a trustee performing, somewhere else. Somebody else did the trust. They may or may not have an attorney who's guiding them. But the beneficiary said, I've called. I've gotten nothing. They don't return my emails. They don't return my calls. But the trustee has a duty to the beneficiary. And yes, a beneficiary who's really being a constant pest, no, they don't deserve you texting them at 3 a.m. But they do deserve to know, here's what's going on. And having regular reporting can help to keep a beneficiary from becoming a pest because they're worried that nothing's being done or they don't understand what's being done or why it's taking so long to wrap up the estate.
Right. And the paying the trustee piece, again, that goes with this duty because you should be keeping track of your time and keep track of everything that you're doing to justify the fee that you are taking from the estate.
Absolutely. Yeah. And also making sure that you're keeping track of expenditures so that you can do a full accounting of where is every penny gone. Making sure you're keeping receipts for such things as, for instance, having a handyman do some repairs around the house before it gets listed. You have to have a receipt for those payments along the way just to make sure that you can really show the record of where every penny went and show that you've been above board the entire time, making sure that things are being taken care of properly, but not, nobody can accuse you of taking money from the trust that wasn't earned or spent.
Right.
Another duty, which we touched on just a little bit in the impartiality, is to avoid conflicts of interest. Now, a trustee who's a beneficiary, there's inherently the opportunity for some conflict of interest. But if you treat yourself as a beneficiary, as a third party, that helps you kind of think about, that's me as beneficiary, not me as trustee. So I always say, what hat are you wearing at any particular time? As trustee, you have certain duties to all of the beneficiaries. But as a beneficiary, you do have certain rights as well that you need to recognize. But the conflict of interest can come in when, for instance, you're the trustee and perhaps you've been living in the house with mom or dad for 15 years, taking care of them, and it's your home. And so you want to potentially buy everyone out. There's a potential conflict of interest there that needs to be carefully handled. And a good attorney can guide you through that, how to handle that. Potentially appoint a special trustee who handles that part of determining the value, what should you pay, if everybody's not in agreement. If you've got a family who's in agreement, then you just want to make sure that that agreement's in writing. To be extra safe, if you're not sure, you can always go to court and have the court approve it. But there are non-judicial settlement agreements that are allowed by the law. So that's another way to get, if everybody signs off on it, then they have complied with the law. And if, this is the price and I'm going to pay you your share, that can work. But you have to really be aware that that is a potential conflict of interest.
Definitely.
The other thing that we just want to mention also is always think in terms of being that prudent person. What would somebody who's being extra cautious and careful do in this situation? That's a great way to think of it. Your fiduciary duties are be prudent in everything you do. Keep good records, keep accounts, keep the property safe, communicate with the beneficiaries. Those are all the big tips that can make your job smoother than if you don't do those things.
Yeah, and we have some do's and don'ts for potential trustees and acting trustees. And you shouldn't move too slowly, so don't procrastinate, but also don't go too fast. So make sure that you're taking your time and waiting for all the assets to come in. It happens frequently where our trustee will tell us, oh yeah, this is all that mom had, and then a month later, they'll get a letter in the mail from a life insurance company that said, oh, there was life insurance policy that your mother owned, and now we have to reopen things and keep it moving. So
yeah, or a debt comes
Right.
to surface.
Yes.
Right. So that's always an issue as well. One of the things that a trustee has to do in Arizona also is to provide notice to the beneficiaries. So it's always a good idea to get that out very quickly and then not try to move too fast right after that, because that also is that opportunity. If somebody is going to contest it, that's their opportunity to complain, because we give them some indication of what their benefits in the trust are.
Right.
So if I'm the beneficiary and I'm supposed to get 30% of the estate, I get the little blurb from the trust that says, Libby gets 30%. So if I thought I was getting 50%, then I might be about to complain. And then, you might have a problem. So sometimes waiting lets you know that there are going to be problems, that you're going to have to be really careful, make sure you don't make distributions too soon, because you want to make sure that you've resolved any problems before that happens.
So it's a careful balance, not too slow, not too fast.
Right,
Be reasonably prudent.
Exactly right. What other do's and don'ts would you like to share today, Allison?
Oh, this one is a good one. So don't let anyone pressure you into doing something now. So it'll come up frequently where a beneficiary will try and pressure the trustee to say, I have a lot of expenses coming up and I need a distribution right now. So you need to hurry up. So
Yeah. And again, that can really trip you up if you think, well, that's okay. I'll just give each of these people $50,000. But then if turns out there's some big case that they didn't know about, there was a lawsuit coming down the road, or there's a huge debt that needs to be taken care of. Sometimes we realize only later that somebody hasn't filed tax returns in ages, so we need to make sure that the IRS is satisfied before the money goes out.
you don't want to make the IRS mad.
Yes.
So it often, or not often, but it will come up where a trustee will have to serve as an incapacity trustee. So this is before the grantor or the trust creator has passed away. And the trustee is now having to act as a fiduciary and care for this grantor while they're still living. So do you want to speak a little bit about that?
The important thing to realize is that the grantor, the creator of the trust, is still the beneficiary of the trust. They're the only beneficiary of the trust. Right. If they have a spouse, the spouse might be a beneficiary. If they have dependents, the dependents may be entitled to be taken care of. So it's important to look at the trust, because the trust tells you all of that. But again, everything that we've talked about really applies to that situation as well, and maybe even more strongly, because that duty to be prudent can include the decision about whether to keep somebody in their home or whether assisted living is better, and looking at the financial picture. Do they have assisted living care
Right.
insurance? Do they have other provisions that might help them to pay for care? Is it a good time to sell the house?
Right.
All of those things can factor into taking care of somebody who potentially has dementia and just simply can't take care of their own finances anymore.
Yeah, these long-term care options can be immensely expensive as well. So it's very important that you're making the right financial decisions by the grantor / beneficiary.
Exactly. And making sure, yes, again, you may be entitled to compensation for your work, but you're not entitled to just take the money and buy a new car.
Or go on a vacation.
Pay off your mortgage. No.
Oh, but mom would have wanted me to pay for this stuff.
Exactly.
No, don't
Not
do
so
that.
much.
Don't do that.
One of the other things that I'll just talk about is when a spouse has passed away, that looking at what the trust provides can be important still. So usually in Arizona, we do a joint trust. So the couple has a joint trust. Often the surviving spouse just carries on as trustee. But there are certain things that they want to be sure that they look at, including what does the trust say after one spouse has passed away? Can it be amended? Is there a split in the assets? Because sometimes the trust provides for the decedent's share of the community property and any separate property be held in a separate trust, which is designed to protect it for the next generation, even if the spouse has that opportunity to utilize the funds in the meantime. And so the surviving spouse, as the trustee of a separate trust that has to be created, does have some obligations to the successor beneficiaries. Even though it's not their money yet, they're not entitled to anything yet, the spouse should be acting prudently with regard to those assets as well.
Yeah, definitely. Another thing that we've been seeing come up lately is there's a child that's a trustee and both of their parents are now incapacitated. So now they're having to care for both parents in that role as trustee. So that's complicated and really difficult and straining on that child.
Absolutely. So another thing that we talk about with our clients who, potentially have had a diagnosis of dementia or recognizing that they're not as sharp on the financial side anymore. We talk to them about going ahead and having a co-trustee at that point.
Great point.
So it's actually a pretty easy process to appoint your successor trustee as a co-trustee or potentially somebody else if somebody else is helping you at this point with handling those finances. So that can be a good way to put somebody in place to get them on the accounts to be able to handle things or monitor the situation to be sure that things are getting paid, that there's been no identity theft or other fraud that might be causing money to escape from the accounts, so to speak.
We don't want that.
So that's something to consider. And again, that co-trustee has all of those same fiduciary duties and loyalty, and owes that to their other trustee who is also the grantor and sole beneficiary at that point.
Yeah, another good note on a scenario like that, if you have a dementia diagnosis and it's still early stages, is refreshing that durable power of attorney, because we see frequently where banks reject them if they deem them stale, which could be any amount of years. We've seen it as few as 3 to 5. So.
Yeah. Absolutely. Yeah, it's a good time if a diagnosis has been made to go ahead and do a full review of everything to make sure, is it still what you want? Are the successor trustees good? Is the trust up to date legally?
Right.
Do we have the right things in place? The durable power of attorney, that's a great time to get a fresh one in place. The other thing we tend to recommend is to go ahead and do the powers of attorney at your stockbrokers. So if you, for instance, have accounts at Fidelity or Schwab, they have their own powers of attorney, and some companies won't take an outside power of attorney. So you need to make sure you fill that one out as well as doing the one that's for more global to handle all the other legal or financial matters.
Right.
Well, we're always happy in our office to help trustees who are starting to serve. We're putting together some materials and videos and a training program for trustees. So keep an eye out here. We'll let you know when that's out. And in the meantime, we're Libby Banks
And Allison Gloss.
with the Law Office of Libby Banks podcast. Thank you for joining us.
Thank you.
Thank you for listening to the official podcast of the Law Office of Libby Banks. If you're in need of an estate plan, please reach out to our team by either calling 602-375-6752 or emailing info@libbybanks.com. You can follow us on Instagram and Facebook. Just search the Law Office of Libby Banks. Free consultations apply to new and existing estate plans only. If an estate plan is not completed or was prepared by a third party, revisions will be given at an hourly rate. This has been a T-Door production. Music by Track Tribe.